What happens when you die without a plan? Jill had two children, one of which she hadn't spoken to in 20 years, and the other one of which takes care of her every day. At Jill's funeral, the estranged daughter shows up and demands her share of the mom's estate. Because Jill did not have a plan in place, Jill's estranged daughter is going to get half of everything. Even a basic will would have made sure the estranged daughter didn't get anything. If you don't plan, you're giving control to the state. The state will decide who gets what, when, how, and how much, not you. In the case of Prince, the popular music artist, the state of Minnesota decided who received his estate. Since he didn't have a will, his sister and half-siblings will take the estate. A judge made the decisions, not Prince. The outcome would have most likely have been the same in Arkansas. When you die without a plan in place, the state of Arkansas has written one for you. The state will take control. The state will control what you had and who gets what, when, how, and how much. All the property you own in your name alone will be subject to intestate succession. Most people call this probate. Intestate or intestacy is what happens to an estate in the case an individual dies without having created a last will and testament or other estate plan. Property, land, money, and more you own in your name alone is called your probate property or your probate estate. This is the property subject to intestate succession or probate. Assets owned jointly or that have a designated beneficiary like retirement accounts and life insurance are non-probate assets. They go directly to the co-owner or beneficiary and are not subject to probate or administration or distribution under the laws of intestate succession. Depending on how real estate is titled, real estate in your name may transfer automatically or it may not. So instead of you getting to decide who's in charge and who gets what, when, how, and how much, the state government, through the courts and a judge, decides that for you and your probate estate. Who gets your stuff? Your spouse, surviving children, and any children of your deceased children will inherit your estate. If you don't have any children, it gets really complex as to who gets your stuff. It depends on if you were married and how long you were married. Who will care for and raise your children? If you have children under the age of 18, then the court will manage their money until they're 18 years old, sometimes 21, then write them a check for the full amount. What are the odds they will save and invest a large lump sum at 18 years old? The court will also decide who raises your children and without your input. What about life partners? If you're not married but have a long-term partner, the results can be devastating. Under the law of Arkansas, your long-term partner will not inherit anything. The intestate succession process and cost. Intestate succession will take 8 to 12 months if everybody gets along. Intestate succession will cost about 6% of your gross estate. Your gross estate is the value of everything you own without subtracting out debts. If your house is worth $200,000 with a $100,000 mortgage, your gross estate would be $200,000. Creditors must be paid before your family gets anything. Final expenses must be paid before your family gets anything. But the financial cost isn't the only cost. Your family will pay in emotions. Your family will have to wait until towards the end of the process to get their money and expenses paid back. High-level overview of intestate succession. If everybody has signed the waivers, then the process can be done in as little as 8 to 9 months. If even one person doesn't sign, the process can stretch out for years. Until it reaches the distribution step, nobody gets anything. Even the overview is long. My detailed checklist has over 115 boxes to check off during the process. Here is a high-level overview of the process. And remember, every time a petition is filed, it also means an order has to go to the judge, and the judge can call a hearing. First, we get everybody to sign waivers. Sign and file a petition to open administration and file the waivers. Pay the filing fee, which is an additional cost. Send an order to the judge to open administration. Once the order is signed, get the administrator to sign an acceptance. File the acceptance and get letters of administration. The letters allow the administrator to run the estate. Place a notice at additional cost in the newspaper. This starts the 6-month window for creditors to make claims. During that 6-month window, you can still appraise assets as required by law. You can sell real estate and other property, which requires a petition and order. Negotiate with creditors to reduce bills. During this period, you need to continue to pay the bills like mortgage payments if the family's keeping the property. Finally, you're going to sit on the money until the 6-month period ends. When that ends, you're going to pay the creditors. Again, petition and order is required. You need to pay the attorney and the administrator, which requires a petition and order. You're going to pay expenses like funeral and medical bills. The administrator has to sign a petition and the judge has to sign an order. You're going to distribute what's left, which requires a petition and order. File receipts from the distribution. File a report of distribution. Get the report approved, which requires a petition and an order. And finally, when that order is signed, the case is closed. If at any step the judge decides that a hearing is needed, or the judge wants a hearing, or somebody didn't sign the waivers, then 20 days is added, minimum, for notice of the hearing. How to avoid intestate succession. You can write a simple will to avoid intestate succession. However, this will lead to regular probate. A will requires probate to be validated and used to distribute your property. The checklist is almost the same as above, only your will controls who gets what, not the judge. You can create a comprehensive estate plan that avoids as much probate and intestate succession as possible. A comprehensive estate plan will keep your major property and money out of probate. Not only does your family get the money and property immediately, but unsecured creditors also cannot make a claim against this money and property. And if done correctly, your residence will be protected from Medicaid recovery. A comprehensive estate plan lets you avoid probate and protects you and your family during your lifetime.